Welcome back, everyone. Um, Day two of this craziness. I guess for classes, really, this is day four of being at home. I've been wearing pajamas for 3 straight days, and I hope you guys are doing well with your classes. I hope everything's going well. I appreciate the feedback you guys have given me so far. Shay, thank you for your words, letting me know how it went. Feel free to write me, guys. Let me know if you're having any issues with anything. I appreciate positive feedback, like Shay gave me yesterday too, just so I have a good idea of what's going well for you and what's not going well for you. So we're going to return to our notes. So we're going to do the second part of that. So go ahead and pull up your federal judicial court notes. Scroll on down to powers of the federal court. You can see yesterday we left off here, judicial branch in the Constitution. So now we're going to do powers of the federal court. All right. Like I said multiple times yesterday, if I'm going too fast or anything, go ahead and hit pause on the video so you can finish typing in what you need. That way, you've got time to type in as much as you need. So, what does the Constitution provide as part of the court system that would balance the powers of the other two branches of government? It'd be the Supreme Court. So our Constitution, our first article, creates our legislative branch. It creates our Congress. Article 2 of the Constitution creates our presidency and our executive branch. Then Article 3, as we said yesterday, really doesn't do a whole lot as far as creating the judicial branch. But what it did do very specifically was set up a Supreme Court. And the Supreme Court was supposed to help balance those three branches. It was going to be the highest level, the most important part of this judicial system, which the rest of it would be created by Congress later on. Now, Chief Justice John Marshall is what ended up giving the Supreme Court a lot of the power. So who helped increase the power of the court? That was John Marshall. We've got one Chief Justice, and then we've got 8 associate justices. So of our 9 Supreme Court justices, the one who's the top, the head one, is named the Chief Justice. So which states have courts deriving their power from the state constitution and laws? All 50 of them. Every state court in the country gets its power from that state's constitution, just like our federal courts get their power from our national constitution. So our federal courts, where do they derive their power? From the Constitution and the federal laws. So Congress makes the laws, the Constitution's already created, and that is what the federal courts get their power from. What is jurisdiction? We're going to continue to hammer this away. Jurisdiction is the authority to hear certain cases. So some courts can rule on certain cases, and other courts will rule on different cases. So when do federal courts have jurisdiction? So those federal courts, when do they have authority as opposed to state courts or other kinds of courts? Well, federal courts have jurisdiction anytime it's dealing with U.S. law, treaties with foreign nations, any interpretation of the Constitution. So a lot of times when we look at the Constitution and we're arguing about what it says, it's the federal court's job to be the ones who interpret it and tell us exactly what it's supposed to mean and how it applies. Also, anything that has to do with bankruptcy or maritime law. Remember, that's law of the sea. So this answer is a little bit longer, so this is one you might want to hit pause for if I go too fast. But what people are involved if federal courts are given jurisdiction? So essentially, if these people are involved, then it's going to be a federal court issue. So ambassadors or any other representatives of foreign governments. So anyone that deals with foreign relations in any way is going to be going to a federal court if it has to do with that foreign entanglement. Anytime 2 or more states of government are involved. So if Ohio is suing Maryland, then that'll be in a federal court because it wouldn't be fair to be in one of those state courts. The U.S. government, so if we're suing the federal government for something or any of its offices and agencies. So if you want to sue, let's say the Department of Homeland Security because they tapped your phones or something like that, then that would be in a federal court. Citizens who are residents of the same state but claim lands under grants of different states. That sounds a little complicated, but essentially, anytime things are involved in multiple states and it's not clear what state it's a major issue in, then it's going to be a federal issue. And the next question, what is it called when state and federal courts have jurisdiction? So this is when a state court and a federal court both have jurisdiction at the same time. We call that concurrent jurisdiction. Now, we've used this word a couple times in this class of what concurrent means. So remember, it's two things at the same time. So if a state court and a federal court both have jurisdiction covering something, that's concurrent jurisdiction. So which court takes priority when there's concurrent jurisdiction? That'd be the federal court. So anytime that a state court and a federal court could try that case because there's concurrent jurisdiction, they both have authority over it, then the federal court has priority if they want it. What is original jurisdiction? Again, one of those terms we're going to keep hammering away. All these different types of jurisdiction. Original jurisdiction is the authority of a trial court to be the first one to hear a case. So the very first time that this issue or this case goes to court, that is a court that will have original jurisdiction. That's why it's called original, because they're the first ones to hear that case. So what can a person do if they disagree with the ruling of their court's trial? We've talked about this. So if you disagree with what's ruled in your court case, then you can appeal, which means I don't like this. I want to take this to another court. That would be like if Mr. Aaron gave you a restricted lunch and you didn't like that, you didn't think it was fair, you could appeal it, go talk to Mr. Eddie. In this case, he would be the higher level court, and see what they think. Now, Mr. Eddie could do a couple things. Mr. Eddie could agree to not listen, which then you still get the restricted lunch. It sticks with my ruling. Or he could overturn it and say, you're right, you didn't deserve that restricted lunch, in which case he's giving a reversal of that decision. So what is appellate jurisdiction? In this example, that would be what Mr. Eddie has. He has the jurisdiction to appeal or to hear appeals. So that is the authority by a court to hear cases that are appealed from the lower courts. That is appellate jurisdiction. All right, we're going to go ahead and continue on to Powers of the Federal Court, Part 2. And then, that'll be our last one for today. All right, so Powers of the Federal Court, Part 2. What can the Supreme Court nor any federal court do? They cannot initiate action. That means that they can't go out seeking certain laws or seeking certain issues. So this is related to the next one. So what can a judge or justice of the federal court not do? They cannot seek out issues and bid both sides to bring it to court. So essentially what they have to do is they have to wait for issues to come to them. They can't go seeking out and being like, hey, we think that law might be an issue, so we're going to test that in court. No, someone has to sue that state or sue due to that law and let it work its way to the Supreme Court. So they cannot be the ones going out and seeking these specific issues. What is a litigant? This is definitely a question that's going to be in your test. It's an important term to hear because you're going to hear it throughout your life. A litigant is any person involved in a lawsuit. You litigate. Sounds like an insult, right? But no, it just means that you are involved in a lawsuit in some way. All right, so what we said a second ago, courts must wait for these litigants to come before them. They can't go out seeking people. Hey, we think that person did something wrong to you, so we're going to let you try them in court. No, they have to wait for those people to sue each other and come to the courts. So what can federal courts only do? They can only determine cases. They have to wait for the courts to come before them, and then they get to determine how that case goes. So they can choose which cases they listen to. You know, the Supreme Court gets thousands of different appeals and people who want to be heard in the Supreme Court, and they get to choose which ones they hear. Then they get to hear the case, and then they get to rule on the case. Federal courts cannot answer legal questions. So you can't, if you're the president, you can't go to the Supreme Court and just ask them a legal question, which you would think, you know, they're the highest level, the ones who know the most about the Constitution. Why can't they answer a question? It's specifically stated in the Constitution that is not their job to answer questions. George Washington found this to be an issue. Him and Thomas Jefferson wanted a question answered. They go to the Supreme Court. Supreme Court says, we'll get back to you. And then they got back to him and said, nope, we're not allowed to do that. We can't just answer your questions. We're only allowed to wait for things to come to us via a court case and then make a ruling on it. Which is exactly what happens here with John Jay. So what did Chief Justice John Jay and the Supreme Court do when George Washington and Secretary of State Thomas Jefferson asked for advice? They refused to answer it. Can you imagine Thomas Jefferson and George Washington, two of the most important people in our country's history, come to John Jay with a question about the Constitution, and John Jay goes, nope, sorry, can't answer that. Because they feel like that's not part of their job. The Constitution says we are only allowed to determine cases, not answer your legal questions. All right. So this question is definitely also going to be on your test. This is related back to our executive branch as well. So what is one of the most important things a president can do? One of the most important things a president can do is appoint judges and justices. And that's because they have a life term. Once they appoint a Supreme Court justice or a federal judge, they get that job until they retire or die. Now, there are extreme cases where they could be removed from office through impeachment, but it's very, very rare. So essentially, if Donald Trump appoints a Supreme Court justice, which he's done twice now, they get that job until they die. So that could be, the next 30 years. So even after Donald Trump is out of office, so this year's an election year, if he loses this year or he wins and has another 4 years, he could have only been president for 4 or 8 years, but two choices he made continue to affect America for the next 30 years because of the Supreme Court justices he chose. So choosing federal and appointing federal judges is one of the most important things a president can do. All right. Obviously, you guys aren't going to be looking at the text on page 307. We're just going to answer it here together. So what did John Adams sneakily do in his last night as president? So if you remember, George Washington is our first president. He serves 2 terms and then resigns. He thinks that presidents should only serve 2 terms. That's more than enough time, then resign. John Adams runs for president, wins, runs for re-election after his first term, 4 years, and he loses to Thomas Jefferson. Well, the night before he leaves office, his very last night as president, he stays up signing judicial commissions for men of his own party, the Federalists. So let me give you an example of how that might work. So Donald Trump is our president right now. It is an election year, so this is a similar situation. Let's say that Joe Biden is the Democratic candidate. President Trump is a conservative Republican. Let's say Joe Biden wins the election in November. And if you remember, our 20th Amendment says that Donald Trump's last day in office will be January 19th. Joe Biden will become president in January 20th. Well, imagine on January 19th, Donald Trump stays up all night, and instead of being on Twitter just starts signing all of these really conservative Republican judges into the federal court that will, remember, be there for 10, 20, 30 years. So by the time Joe Biden gets in there, all of these people that Donald Trump just put in there are going to be there, and he can't do anything about it. So our next question, how did this make Thomas Jefferson, the new president, feel? Well, it makes him really angry. You can imagine that now the courts are stuffed with people who don't agree with the way he thinks government should be run. So what did Thomas Jefferson do about the 4 justices that had not yet been sworn in? He stopped the delivery of the remaining commissions. Basically, all these judges get sworn in to their bench and start their job, but there's 4 of them who hadn't done it yet. So when when Thomas Jefferson becomes president, he stops those 4 from getting their job, even though they had already gotten letters and approved by the previous president. So this causes a big issue. So our one of those 4 judges, William Marbury, decides he's going to file a lawsuit in the Supreme Court under the provision of the Judiciary Act of 1789, which is what added all of these new judges in the first place. So he says, hey, all these new judges get added. The previous president already signed all my paperwork. I should be a judge. It doesn't matter what the new president wants or not. I should already get it. So we have our Chief Justice, John Marshall. This is a really important thing. This is something we'll talk about over and over again. I'll probably send you guys a video about this. But when I talked about Marbury v. Madison, this is one of the most important cases, probably the most important Supreme Court case in the history of our country. So Chief Justice John Marshall, he decides on this ruling. He announces that the ruling that Marbury's rights had been violated and that he should have his commission. So basically saying, hey, these judges are right. They should get their commission. And he doesn't stop there, though. He could have just stopped there and everything would go back to the way it was. These judges would get their job as federal court judges. The new president would be mad, but everything would be fine. But instead, he keeps talking. And he says, he adds, not only their rights were violated, but the Judiciary Act of 1789 gave the courts more power than the Constitution allowed. And therefore, the courts could not force the commission of Marbury. So these judges, these 4 judges who were being stopped from getting their job, he's saying the Supreme Court does not have the power to make that happen. And ultimately ruled that the Judiciary Act of 1789 was unconstitutional. So this is the first time in the history of the Supreme Court that anything gets ruled unconstitutional. So we've talked about this a few times this year about what it means to have judicial review and have the Supreme Court rule something unconstitutional. But this is the thing that created that. That wasn't a thing that did not exist until John Marshall, the Chief Justice at this time, made this ruling, thereby creating it. So what did John Marshall do or secure by ruling in the way that he did? He secured the court the power to review acts of Congress and gave them the power of judicial review. Man, that felt really wordy. I don't love the way I'm explaining this to you. I wish I was there in person so I could ask you guys how this was going. In short, there was no easy concept, no really understood concept of judicial review prior to this court case, Marbury v. Madison. But the way that the Chief Justice rules gives the Supreme Court the power of judicial review. So which Chief Justice is key in extending the power of the judicial branch? That is John Marshall. There's a lot of interesting stuff about John Marshall. Maybe we'll find a video and I'll have you guys watch that at some point. All right, next question. What did Roger Taney rule in the Dred Scott v. Sanford decision? So we're going to talk about a few different cases, some that are pretty important, some that really made the courts important and powerful, like Marbury v. Madison, and some that really hurt the courts and really hurt the people's faith in the courts. And that would be an example of what the Dred Scott decision was. So Roger Taney rules that African Americans were not and could not be citizens. The Missouri Compromise was unconstitutional, and Congress was powerless to stop the spread of slavery. So this is the Supreme Court, our Chief Justice, Roger Taney, basically saying slavery was allowed and Congress could not stop it. As you can imagine, everyone that was in the North at this time was very upset with this decision. And this would really, really hurt the people's belief in and the standing of the Supreme Court, with it ruling that slavery was okay, essentially, legally speaking. What does due process clause say? So in our Constitution, what is a due process clause? The due process clause says that no state may deprive any person of life, liberty, and property without their due process of law. So you get to have the process of law. You can't just be thrown in jail without going through the whole process first. You have to be arrested. You have to be charged with a crime appropriate. You have to be. You have to have a jury. You have to have a lawyer. You have to have all of these things. There has to be this process of law. It can't just be taken from you. So everyone gets their due process. That's a due process clause. All right. Another one of these, actually, this one is a collection of court cases. They're called the Slaughterhouse cases. It ruled that the 14th Amendment did not increase the rights of an individual. So remember, that's part of our Civil War amendments. A lot of these are going to test whether or not these amendments we make in the Constitution apply to specific issues, and this was one of them. Next one. What case overturned Plessy v. Ferguson? Plessy v. Ferguson is the one that said that we were allowed to segregate, and so long as things were equal, they could be separate. We call it the separate but equal. So are you allowed to have segregated schools? Could you put all of the black kids in one school and all the white kids in another school? And Plessy v. Ferguson said, yes, you could do that. Well, some years go down the line and another court case comes, Brown v. Board of Education of Topeka. One of the most important and famous court cases in Supreme Court in American history. And it overturns Plessy v. Ferguson. That's very rare. It's rare that the Supreme Court, or any court for that matter, will reverse a law or a decision that the court previously made. They really like to stand on precedent, things that have already happened, and rule in the same way. But this was a big deal because this said that if you are going to segregate, if you're going to separate people based on their race, it doesn't matter if the facilities are equal. It is going to inherently be unequal. It's going to inherently be bad for society if you're separating. So it cannot be equal, it cannot be fair if you're separating things. So Brown v. Board of Education is what integrated our schools and let blacks and whites go to school together. Now, this is a good example of how Supreme Courts are largely a product of the national consensus, or what people believe at that time. So today it is pretty common, not everywhere, but it's a pretty common belief that people of the same sex should be allowed to be married. Now, 20 years ago, 50 years ago, 100 years ago, that was not the case. Most people did not believe that. And that's why, within the last 10 years, the Supreme Court did make a ruling saying that it was illegal to outlaw same-sex marriage. So now people of the same sex can get married. And that's an example of how over time, as the national consensus, as people's beliefs in the country change, the Supreme Court changes as well, just like Plessy v. Ferguson and Brown v. Board of Education. All right, so that's the next set of notes. We're going to stop there for today. I hope this worked well. Please, guys, give me feedback. I feel like I'm supposed to say like and subscribe below. Pound that subscribe button. But if you guys have any feedback, let me know. Let me know if this is working for you or if there's any other great things that your teachers are doing. So maybe we can try them too. I hope you are doing well. I hope you guys are getting outside a little bit as you can. And I miss you guys and hope to talk to you soon. See you guys.